Horse racing, as we know, is a billion-dollar business and a significant part of Kentucky's economy.
But over the past decade, wagering on historical horse racing has expanded across the state.
But one Kentucky group is challenging whether or not this fits the definition of pari-mutuel wagering. As LEX 18's Conroy DeLuche reports, the case is now in the hands of the state Supreme Court.
The basic definition of pari-mutuel wagering is when bets are taken and placed into a pool. Players are basically betting against each other. The issue at hand today for the Supreme Court is historical horse racing on these gambling machines. The Family Foundation questions, how can this be considered pari-mutuel when you don't know who you're actually wagering with or against? Only the machine knows.
But the precise issue today is whether or not, in order for wagering to be pari-mutuel, do players have to be wagering with, among, or against each other on the same uncertain event or group of events? The appellees, the racetracks, and the racing commission say they do not. The Family Foundation says they do.
This issue has reached the Supreme Court before, back in 2014. Attorneys for the Horse Racing Commission argue that this is just a repeat of that same argument, and it's a ruling that went in the industry's favor.
Because the question is simply, does this type of wagering fit the pari-mutuel definition that was approved by this court and found to be valid back in 2014?
Historical horse racing has continued to expand since that time across the state, and the attorney for the Family Foundation points out that this has all happened without any action beyond the courts from lawmakers, when this, he argues, is a policy issue.
Where the tracks have had an opportunity to have a monopoly in occupying the gaming space without a single action of the legislature, a vote of the people, or even an executive order.
The Horse Racing Commission representation argues that intervening by the General Assembly has not been necessary, and they pointed out their contribution to the state's general fund through excise taxes.
This decision revolves around whether historical horse racing in its current incarnation is truly pari-mutuel or not. If it's not pari-mutuel, then unfortunately they would have to discontinue. And that would have deleterious consequences for both the associations, the patrons, and racing as an industry.
After almost 2 hours, the argument's finished. Now the case is in the hands of the Supreme Court, but there's no timeline of when they will make that decision. In Frankfort, Conroy DeLuche, LEX 18 News.